Welcome to U.S. Law Shield News Update in Houston, Texas. I'm Sam Malone. As always, visit our website, uslawshield.com, for legal education, member stories, program details, and more. And joining me today, independent program attorney Emily Taylor via Skype. Emily, how are you?
I'm great, thank you.
Get right to it. A shooting in Arlington, Texas. Late Saturday night and an early Sunday morning. A car owner realizes his car is being broken into by, I believe, a 17-year-old and a 19-year-old. Comes out, uses deadly force, kills one of them. Let me ask you a question about homeowners' rights and the use of deadly force and someone breaking into your car, for instance.
Well, there are a lot more rights inside the home than there are when we talk about moving outside the threshold and what's happening in your yard, on your property even. And this issue of someone burglarizing your vehicle is actually a little bit touchy. The law will only authorize deadly force if it's happening during the nighttime. It falls under our theft during the nighttime category. And so, unfortunately, if this incident had happened during the daytime, I think that homeowner might have been in quite a bit of trouble.
So he comes out, he has his shotgun, kills one. Had it been high noon, the homeowner with the gun would have been in trouble. But because it happened in the wee hours of the night, 2 a.m., 3 a.m., he's in the clear.
Well, he may be in the clear.
I should say, I shouldn't say in the clear, but the law is more on his side.
Yes, so he has a statutory authorization. That doesn't mean that he's not guilty of some sort of criminal offense here. The reason for that is that even if the statute authorizes deadly force to respond to theft during the nighttime, a jury may ultimately still be in the position of determining whether or not that deadly force was reasonable. The age of the offenders could sway the jury into thinking that it was unreasonable. If there was nothing in that car but a little bit of change in the ashtray, that could sway them into thinking this was an unreasonable use of force. So he may be in the clear for this action, but it's really hard to say at this point.
And also, I'm going to take this from WFAA in Arlington, Texas. They said the homeowner confronted them with a shotgun, the two Utes breaking into his car. He's quote, at some point during this confrontation, when the suspects were trying to flee, there was a shooting. How about the use of deadly force to protect property when the guys are already running away? How does that play into the scenario?
Well, that further complicates things because you can only use deadly force against someone who's fleeing if they're actually fleeing with your property. And not only if they're fleeing with your property, but also you have to have either no reasonable means of recovering that property other than the use of deadly force, or if you were to say go tackle them or do something that's a use of force, not deadly force.
Right.
If that could really subject you to serious bodily injury or death, then you have the authorization to use deadly force. But running away without property in your arms, that's typically a no-no for shooting someone in the back.
And the homeowner also said, quote, he feared for his life. That's what he told the police. Can you fear for your life when people are fleeing?
Well, I think it depends. Sometimes, as a defense attorney, I might argue that it takes a while for our brains to catch up with our fingers in terms of exactly what's happening, and these situations move very quickly. Also, I think that sometimes people think that using the right buzzwords with police will get them out of trouble. Unfortunately, I'm in fear of my life isn't a get out of jail free card if the evidence doesn't support it.
So if you say, I was in fear of my life, and both guys are shot in the back of the head, you may have a little problem there.
Absolutely.
Amazing. U.S. Law Shield News Update. Sam Malone here with independent program attorney Emily Taylor. Another big story, of course, the swearing in of Attorney General Jeff Sessions, formerly a senator, now Attorney General. As big fans of the Second Amendment, should we be able to breathe easier with a pro-Second Amendment Attorney General, or is he?
Well, I think he is. The NRA sure thinks he is. They've backed him. And he does have a pretty good voting record on firearms issues. He's voted not to restrict, quote unquote, high capacity magazines. He's voted not to close, of course, what we refer to in the general vernacular as the gun show loophole. He's done some good things in terms of his votes. So I think that we can breathe easy. I have one concern about Attorney General Sessions, though, and that's that he seems to want to bring in federal authorities to enforce federal gun laws in the states, which in a lot of instances I think is good. I think we should be enforcing the laws that are on the books rather than crafting new ones. But in Texas specifically, we have a lot of areas of Texas gun law that are actually more lenient than the federal law. And so it would really be a shame to see people who are in compliance with Texas law all of a sudden have the federal authorities busting down their doors and facing federal prosecution.
Independent program attorney Emily Taylor on our U.S. Law Shield News Update. Give me an example of a Texas gun law that is more lenient than, let's say, federal law.
Sure. A great example is having your gun within 1,000 feet of a school. So in the state of Texas, we can all have our concealed handguns in our vehicles, through the Motorist Protection Act. So if I were to drive by a school with my concealed handgun in my vehicle, I'm not committing any sort of criminal offense in the state of Texas. I can't take my gun into the school, but driving past the school, I've got nothing to be concerned about. Now, the federal law says that I cannot do that unless I have a license to carry a handgun from the state of Texas. So for all of those, I'm sure thousands of people every single day who drive through a Texas school zone with a pistol concealed somewhere in their car but don't have a license to carry that pistol, they're in full compliance with state law, but they're actually violating federal law.
To quote Ed McMahon and Johnny Carson, I did not know that. So even if you drop your kid off at the little, drop-off place at the school, in Texas, legally, you're okay, but in other places, you may not be okay if the gun is in the vehicle and you kind of pull right up under the overhang in the front door of the school.
Exactly.
Okay.
Texas law says that is a totally lawful activity. Federal law, you might be in trouble. Another example, although it doesn't affect as many gun owners, is felons who possess firearms. Texas law says that if you're convicted of a felony, you can possess a firearm in your home for self-defense after you've been off paper, defense attorneys like to say, but after you've been essentially out from under state supervision for 5 years. Federal law says you can never possess a firearm. They don't care how long ago that felony conviction was. So, potentially there are instances where a Texan who has a felony conviction from the 80s when he was just a young, stupid kid has a gun in his house. Texas law says he's good to go, but federal law could come in and impose a really strict sentence against him for unlawful possession.
I did not know that. You have made us all a lot smarter. You know that? By stopping by
Wonderful.
today. Independent program attorney Emily Taylor joining us today via Skype. I appreciate your time. Thank you for the updates.
Well, thank you for having me.
That wraps up today's U.S. Law Shield News Update. In Houston, Texas, I'm Sam Malone. As always, visit our website for more information, uslawshield.com.